This is Paul. Yeah. Now, just looking at the overview of the Federal Rules of Evidence. Yeah. This is from 1998. There's some suspicion of juries. Yeah. In order to control the human interference of juries present in the courtroom. Yeah. Uh, serve substantive policies such as allocations of burden of proof. Yeah. Serve policies outside the courtroom, such as protection of privileged communication, settlement negotiations, etc. Yeah. Then there's the control, the scope and duration of trials. Yeah. And then ensure accurate fact finding. Now, I've been on trial for approximately 16 months. And I have a court hearing 2 days from now where I'm going to be found, well, restorable, but delusional. Yeah. Mhm. And then I'm going to go through 3 to 6 months of being involuntarily admitted to a mental institution where they're going to administer psychotropic medication against my will so as to restore me. Then I'm going to go through another, well, 6 to 12 months of trial, right, where I'm going to have the compulsory right to call the petitioner to the stand and ask her, well, why didn't you sign the protection order? And then she'll say, well, you're crazy. I don't have to answer any questions. I'm the victim of trauma. Victimization. Now, somewhere between now and approximately 2 years from now, the control of the scope and the duration of the trial of the two-count criminal complaint, yes, where the state assumes no liability for any of the actual information provided on the state court website, but the prosecuting attorney says, well, it's a guarantee. Where police and sheriff's departments are not liable for what they've sworn and they don't have to enforce the laws. Yes. I'm the individual that for the next approximately 2 years is going to be on trial, going through the restoration process. No speedy trial. Never being able to have any witnesses in my favor. Never having the right to admit any evidence in my favor. My sons, they're going to continue to be enrolled in a school where they're 2 grade levels behind the rest of the students. And my family's going to be victimized by the state of Washington, every state of the United States, and the United States of America. Now, controlling the scope and the duration of the trial, when you took me off the docket for 10 weeks, yes, I'm sure Judge Landis agreed completely that, well, we'll just set it aside. We'll take him off the docket. It doesn't matter. And when you cancel court hearings with no explanation to myself, the excuse for every action and reaction of the trial attorneys, the prosecuting attorney's office, and the public defender's office is he's crazy. There are no rules of evidence when somebody is obviously insane. Now, let's say I was able to sue you for violating these federal rules of evidence and the actual duration since the video arraignment on September 19th of 2017, yes, to the signing of the criminal complaint on August 2nd, yes, to the filing of the actual two-count criminal complaint in court without a judge or magistrate on August 8th of 2017, yes, for a court date on August 21st of 2017 where I asked you to inform me what it was about, and you said, well, as long as you read about it on the court website, it's good enough for us. Now, I know I've got to go to court on Friday, and I really want you to issue that court order where you admit me to a mental facility because you're so smart. Yeah. Now, this right to a speedy trial, 14 months later, not like there are any rights at all of those that are accused. Now, there's the big question of who is it that determines the admissibility of actual evidence? Yeah, judge versus jury. Who decides generally? Judges will determine whether evidence is admissible. Juries will be allowed to determine if evidence is credible. Well, He never allowed me to admit any evidence on my behalf. He wouldn't allow me to admit the evidence that I was in Port Angeles, Washington on June 16th of 2017. And that removes the judge's obligation to determine if it's admissible. That's right. Judge Porter wouldn't allow me to admit the evidence of the protection order not being admissible. I wasn't given any notice or opportunity, but he had no jurisdiction to remove it. Wouldn't allow me to admit the evidence that there was forgery and fraud on the actual protection order because I had knowledge of it and you served me in the Swin Public Library, so that's how it is.